All right. Good day, everyone. And thank you for joining today's Ask Me Anything, where we answer your questions about cannabis legalization in New York. We do this every Wednesday at 4:20 p.m. New York City time. I'd like to welcome back those of you who have joined us before. And for those of you who are joining us for the first time, I hope you'll make it a regular occurrence. My name is Jeffrey Hoffman, and I am an attorney in New York, and my legal practice focuses entirely on cannabis. If you would like to contact me, you can do that either here on LinkedIn. I welcome all connection requests, or you can also contact me at my email address, which you see on the screen, info@420jurist.com, which I guess you might say makes me the 420 jurist. And as the 420 jurist, I will be answering your questions, roughly half of those questions, from a list that I've gathered from previous Ask Me Anything sessions, and roughly half from questions which you post in the comment field here today. So if you'd like to ask a question, now is the time to do it. I do need to give a quick disclaimer before we get started. I am indeed an attorney, but I'm not your attorney, at least not yet. I did notice that there's a few of my clients in the event today, so you folks don't need to worry. I am still your attorney. But for the rest of you, I am not your attorney, and today's event is not legal advice. It does not create an attorney client relationship, and it is not a solicitation to offer legal advice or legal services. And so, with that, let's get to the questions. I'm going to start today with some of the questions from the backlog. And the first question is, what if we were a micro business and we wanted to process flower and sell that, but not grow? So the quick answer to that is you would not be able to do that. According to MRTA, within the definition of a micro business, it says that a micro business can be vertically integrated. That means it can be a cultivator, a processor, a distributor, and a retailer. Excuse me. However, it has to do each of those things for their own adult use cannabis and cannabis products. So I and pretty much everyone I've spoken to has taken that to mean that if you want to participate in any part of the value chain as a micro business, you need to be doing that with your own adult use cannabis. So if you wanted to process flower, you would indeed also have to have grown that flower. Now, it is entirely possible that the Cannabis Control Board makes some changes to that in the regulations, which we hope are forthcoming ideally later this summer. My guess is that they probably will not undo that restriction. That seemed to be something that the legislature was pretty keen on having within the law, that the micro business being fully integrated would require that the micro business licensee only do things within the cannabis value chain of their own adult use cannabis and cannabis products. And my guess is that is indeed how things will play out once the micro business license gets issued and people start opening their businesses as micro business licensees. All right, let's get to another one from the backlog. And this question is, does the previous conviction in New York requirement apply to delivery licenses? And the answer to that is no, it does not. The previous conviction in New York requirement is only applicable to the conditional adult use retail dispensary license. The requirements for that particular license are that indeed an individual was convicted of a cannabis offense in the state of New York prior to March 31st, 2021, the date that the cannabis law came into effect. And additionally, that individual has to demonstrate 10% ownership of a business that was profitable for at least 2 years. So that is the special conditional adult use retail dispensary license. For those of you that have been tracking that license, the public comment window for that ended on May 31st, about 3 weeks ago, a little more than 3 weeks ago. There is a Cannabis Control Board meeting tomorrow, and I don't know whether or not they will announce anything related to this conditional adult use retail dispensary license. My understanding is that there are probably going to be some changes to the original regulation that was proposed. Another excellent lawyer that I'm regularly in contact with, a gentleman, Wei Hugh, who some of you on the broadcast today may be familiar with, he indicates that at the very least, they're going to want to add back in to the conditional adult use retail dispensary license the requirement that any licensees go before either the community boards here in New York or the appropriate authorities in other states to notify them that they are going to be opening this business and allow those boards to comment. It is interesting because those locations are going to be locations set up by DASNY. So it'll be just very interesting how that goes about. Obviously, DASNY will be selecting the locations, but I guess if Wei is correct, and I have no doubt that he is almost certainly correct, that this requirement will simply have those licensees have to go before the community boards and present their businesses in the locations where DASNY has selected that they open those conditional retail licenses. Now, as to the actual question that was asked, whether or not that conviction requirement applied to delivery licensees, it does not apply to delivery licensees. The delivery license is one of the 9 standard licenses that were called for in MRTA, the legislation passed by the legislature, whereas the conditional adult use retail dispensary license, as we've just mentioned, is a proposed regulation by the Cannabis Control Board. And assuming that they are going to make the modification, at least the one that Wei had indicated is likely, and perhaps other modifications, that will require us to go through an additional waiting period known as a revised rulemaking period. It is 45 days. So if the Cannabis Control Board gets everything in order and that regulation is promulgated through the state register in a timely fashion, it would be another 45 days, which from now would roughly put you somewhere into August. And if that indeed is the case, you could potentially see the application for that license becoming available in August or perhaps very early September, right after the Labor Day holiday. So the state is clearly moving along with that license. It does appear that they still are waiting on the big body of regulation that we're going to see for the 9 standard licenses, but it does look like we will see some progress for that conditional adult use retail dispensary license. But as the questioner wanted to know, that is not a requirement for the delivery license, so we will learn a lot more about that in future regulation. Questions from the group today. When will New York open registration for those that are not previously convicted of a cannabis charge or minority businesses? Now, it's a good question. The question does conflate 2 things there. The initial licenses that we have seen available, the most initial one, or the first initial one that we saw, was the conditional cultivation license. Many of those licenses have already been granted, have several farmers that have seed in the ground. If anyone currently on the broadcast today either wants to share with me some pictures of their crop or knows some farmers that would want to share pictures of that crop in the ground, I would love to have that and would certainly tag you in a post related to that on LinkedIn. But so that is the first license that was made available. We just reviewed the conditional adult use, and I should back up, that conditional cultivation license was only available to individuals that were already in the state's hemp program and already had experience growing hemp in the state's hemp program. The conditional retail dispensary license, which I mentioned previously in this discussion, is the only license that requires a conviction in order to be eligible, a conviction of a cannabis offense to be eligible for that license. Generally, the minority business is one of the classes that will be able to apply for the standard cannabis licenses, but as a social and economic equity applicant. So I think that's a real difference that we need to make very clear. Many people that I've talked to do tend to conflate some of these issues. So just one more time to really clarify it, the only license that requires a conviction, a previous cannabis conviction, is the conditional adult use retail dispensary license. That is a very, very specific subset of social and economic equity applicant. And the rest of the social and economic equity applicants, in particular, minority businesses, women-owned businesses, distressed farmers, service-disabled veterans, and the what I think will be the largest group, those that are in communities that have been disproportionately impacted by enforcement of cannabis laws previously. They will simply be able to apply as a social and economic equity applicant for one of the 9 standard licenses. And there are all kinds of benefits related to applying as a social and economic equity applicant. I just do think it's very important that we differentiate between the requirement of a conviction for one very specific conditional license and the social and economic equity applicants that will be applying for the standard licenses. All right, let's go back to a few of the questions from the backlog. Is New York going to let delivery licensees white label products or only deliver for retailers? For example, the Uber Eats model. From my perspective, this is a very interesting question, and frankly, it is an open question. I know there is a place in the definition of the retail dispensaries where it talks about them being able to deliver. I've had discussions with folks about whether or not that means deliver in the sense of delivery like Domino's Pizza, or simply deliver in the sense of deliver it across the counter to people that are shopping in their stores. I think there's a reasonable argument to be made for both. Additionally, as some of you may know from previous discussions, the delivery license is the one that we know the absolute least about. If you look in MRTA, it is the license that has the fewest lines of legislation written about it. So I do think it is an open question as to what is going to happen here. I have also shared on previous sessions that I did put in a question to the OCM during the cannabis conversations, and I did receive an email from them that indicated that their current thinking was that delivery licensees would only be able to partner with retailers, with dispensaries. So an order would go into a dispensary, and the dispensary could have the delivery guys deliver it. I think there's only a couple of scenarios under which that makes sense. And that would be if you are going to limit the delivery license holders to only being able to deliver orders that go into retail dispensaries, then you cannot allow the retail dispensaries to also deliver. Similarly, if you do want to allow the retail dispensaries to deliver, that is, get one delivery license of their own and have 25 FTEs deliver, then you also have to let the delivery licensees hold their own inventory, have their own product, and not have to partner with the dispensary. So from my perspective, it really would devalue the delivery license if you are going to do that. Now, it really is just going to depend on how this all plays out and what the Cannabis Control Board is going to want to do with that. But again, it seems to me the two ways that would make the most sense is either one, you don't let the retail dispensaries deliver, and only the delivery licensees can deliver, and therefore the retail dispensaries would have to partner with a retail licensee to be able to have delivery, or you let both of them hold their own inventory and off they go. So it's a great question. It's one I've talked with many, many people about. It's just not clear to me what is really going to happen along those lines. All right, let's get back to a few questions in the from today's session. All right. And there was a partial answer to it, I think, in the comments, but I'm going to go ahead and ask and answer it anyway. If I'm fortunate enough to get my conditional social equity dispensary license, and considering I'm currently building a cannabis brand, how would I be able to sell branded cannabis products if I'm just limited to a dispensary license? So within the inventory you're going to be able to get for your dispensary, you're going to be able to stock any brands that you want. Now, if it's a brand that you've developed, as I believe the respondent said further down in the comments, you are not going to be able to act as a cultivator or a processor to create those products. But as you do suggest in your question, you could potentially license your brand to cultivators or processors and have them be responsible for actually doing the cannabis parts of it, and then have that brand be part of your inventory in your store. I do think that that will be a bit of a challenging component for you to do, but it's certainly not impossible. At least we've not seen anything yet in the law or the regulations that would prohibit you from licensing a brand name to an organization and then having them use that in cannabis. We will need to look into some of the very specifics. There are things about not being able to have an economic interest on certain entities. It does not clear to me that a licensing agreement would qualify as an economic interest. Usually, you would think of that as some kind of stock ownership or loans that are out into those entities that have to be paid back. But I do think we'll probably see some more clarification about that from the Cannabis Control Board once they actually get all of the regulations in place. But the big picture answer is you would not be able to act as a processor at the same time as you had a conditional adult use retail dispensary license. If you really wanted to act in the entire value chain, my recommendation would be that you become a micro business. And in being a micro business, even though it's your own adult use cannabis, you can be a distributor. So you could grow and process the cannabis to create your branded cannabis product, and then you could distribute it to other dispensaries and on-site consumption lounges, as well as sell it yourself at retail. So that may actually be a better license for you if that's the direction that you wanted to proceed. All right, let's go to another question or two from the backlog. Cooperative license and independent license. Can you be involved in both? And by independent license, I'm going to assume that the question asker meant any of the other standard licenses. So cooperative license is one of the standard licenses, and I'm going to assume the question means if I'm on a cooperative license, can I also get one of the other 8 standard licenses? And the answer to that question is no, you cannot. And I always like to read very specific language from the law if we have it on point for this. And I will do that. This comes from the section about the cooperative licenses. And it reads as follows. No natural person or member of an adult use cooperative license may have a direct or indirect financial or controlling interest in any other adult use cannabis license issued pursuant to this chapter. So that reads to me that indeed, if you are going to get on a co-op and be a participant in a cooperative license, then no, you cannot participate or have an economic interest in any of the other licenses that are available under MRTA. All right, let's do a few more questions from the backlog. We had a discussion or an answer last week about your ability to possess cannabis. As it currently is written in the law, an individual at any point when they're just walking about the streets of New York City or anywhere else in New York State can possess 3 ounces of flower and 24 grams of concentrate. The question, as it was asked last time, were just what were the limits for each of the kinds or formats, if you will, of cannabis. And then we got another question that came in. Is that an or an and? And indeed, in the legislation, it is an and joinder. And so that means in one pocket, you could have 3 grams of flour. And in the other pocket, you could have, 3 ounces of flour. And in the other pocket, you could have 24 grams of concentrate. And you would be within the safe harbor in MRTA as far as your possession of cannabis and cannabis products. All right, let's do another one. And I think some of this came into one of the questions today, but it was also in a previous one. So we'll ask this one. Will farmers with conditional licenses be selling directly to conditional dispensaries, or will distribution be up and running by then? Do you have an idea about a timeline for when conditional dispensaries will launch? All right, so really two questions there, somewhat related, but really getting at two separate topics. Let's go ahead and answer them both. As to the first one about the conditional cultivation licensees, those folks that already have the first adult use cannabis crop in the ground and will likely be harvesting in October, perhaps early November, depending on what latitude they are located at, they will indeed be able to distribute without going through separate licensees. And again, in the legislation that was created by the New York State Legislature related to this conditional cultivation license, we have some very specific language about that. So, again, when we have very specific language about that, I always like to read it verbatim. So, the provision reads as follows: licensees would be temporarily allowed to minimally process and distribute cannabis products without needing a separate processor or distributor license, provided that such products are in the form of cannabis flower until June 1st, 2023, at which point any conditional adult use cultivator seeking to process and distribute cannabis products shall be required to apply for and receive a processor and/or distributor license to continue to conduct this activity. So, until June 1st, 2023, a little less than a year from now, the conditional cultivators will be able to minimally process and distribute the cannabis that they have grown to retailers uh, without having to go through those other individuals or having to get their own processing or distribution license. As you may be familiar, when it comes to the standard licenses, a cultivator will be able to get one license to process and one license to distribute their own cannabis. That is the cannabis that they grew. However, the conditional cultivators have been granted this exception until June 1st of next year. So they will not have to get those separate licenses until that time. And they will be able to minimally process and distribute that cannabis. It will have to, however, simply be cannabis flower. They will not be able to go on to any of the more robust processing that would create concentrates or other types of products. Now, I will note that there is indeed a conditional processor license that was created in the same legislation that created the conditional cultivation license. For whatever reason, the Cannabis Control Board has chosen not to open the application for that license yet. I would be very surprised if they don't do that here in the near future, or certainly by the end of the year, but perhaps they have their own reasons for not doing that at this time. Obviously, I think it would be beneficial to do that so that there could be some more robust processing of cannabis products, although it may be that the Cannabis Control Board only wants flower to be available in those initial dispensaries. I think that's an open question and something that we will learn more about in the coming weeks and months. The second part of the question was, do you have an idea about a timeline for when conditional dispensaries will launch? Yes, and we did talk about that just a little bit earlier in the discussion today. I do think that it appears we're headed for the additional 45-day revised rulemaking period for the conditional retail dispensary license. That would, again, depending on when they get it in the state register, that would likely put us out somewhere in late August or early September when the regulation would become official. And at that point, the Cannabis Control Board would be able to create and open the application for those licenses. Again, it looks like it will likely be October and early November before the cannabis crop that we currently have in the ground is harvested. You then have to throw in some additional time for drying and curing of that crop. So I do think the Cannabis Control Board's goal of having those stores open and selling cannabis by the end of the year is still possible. There is clearly a roadmap for that to happen. Everything will need to continue to go right. That is, this regulation needs to get finalized, promulgated, and the application goes up. The state needs to build out the locations where the conditional retail dispensary license holders are going to have their stores. The RFP for a design build partner for that process actually closed yesterday. So the DASNY, the organization that is going to be doing all of that work, has all of the RFP responses in hand so that they can select one or more vendors to be their design build partner. And that really will give us a solid roadmap, assuming everything else goes well and there's not too many lawsuits related to this process. I'm quite certain there will be lawsuits related to it. But if those are able to be addressed with alacrity, then I do think there's a roadmap for those stores to be opened by the end of the year in the way that the Cannabis Control Board has stated they wish it to happen. All right, let's go to a few more questions from today's participants. Are there licenses for small craft growers going to be available? And I think the answer to that is yes. That is indeed the micro business. The micro business is going to have some limitations on it, be that canopy size or number of plants or square footage of the location where you can grow, which is roughly the same as canopy size, but perhaps not. Maybe it's going to include the entire square footage of the facility. Maybe they're going to have limits on the number of employees you can have. We have to wait for the regulations to come forth, but there will be some limits of that nature on the micro business. But I do believe that this micro business license was envisioned to be exactly what you would see as far as the micro or small craft beer industry, right? So I was in Virginia recently, and right next door to a medical dispensary was a micro brewer, a very interesting combination there. And the micro brewer was able to both brew and sell at retail within his same facility. So that is often an exception that is made for microbrewers, and we have a similar kind of exception for the micro business in the cannabis industry here in New York. It's the only entity that is going to be able to be fully vertically integrated, be able to participate in all parts of the cannabis value chain. So that is the license that I would say would be most comparable to the microbrew industry that we have here in the United States. And again, I think that is the license that would be most applicable to small craft growers as far as the license that they might want to attempt to get. All right. Let's see. Great question here. Are pre-rolls considered flower or processed cannabis? So that's a fantastic question. I would probably put in a question to the OCM to get their ruling on that. My take is that since the cannabis that the conditional cultivators will be able to provide, that they are able to minimally process and then distribute. So certainly trimming is allowed. It seems to me that that is an activity that a conditional cultivator would be allowed to do anyway. And since a pre-roll is simply flour, which has been broken down and put into a vehicle that makes it easier to carry around and then smoke, it does seem to me that it would make sense for that to be allowed, and that simply the types of processing that minimal processing does not account for would be creating shatter or rosin or diamonds or any of the other wonderful concentrates that our industry has invented. Those are the things that I don't think would be allowed. But it does seem to me that it would make sense that pre-rolls would fall under the minimal processing requirement. However, I send in questions to the OCM all the time. They usually reply to me within 1 or 2 days. So it'd be a great question to ask them and get their opinion on it. But my opinion, if I had a client that said, don't ask the OCM, let's just do it, I would say you doing pre-rolls is probably a pretty safe place to be. But who knows? I would recommend just asking the OCM. Very friendly folks, and they'll give you an up or down answer one way or the other. All right, so we've approached 4:50 here, and I think that's going to wrap it up for today's questions. I want to thank everyone that has joined us for today's session. Just as a reminder, we do this every Wednesday at 4:20. So 4:20 New York City time. So please join us next week and every week going forward. It's going to be a great cannabis industry. Going to have a lot of questions about it and happy to answer them as you have them. If you're not currently a connection of mine on LinkedIn, please reach out to me for a connection request. I welcome all connection requests. And as I say each week, I know we're all very excited about this forthcoming cannabis industry in New York. But the most important thing that the cannabis law changed is that it allows all individuals who are convicted of cannabis offenses to either automatically or via application get their cannabis convictions expunged from their records. And most importantly, we need to work on getting all of the folks that are still in jail for nonviolent cannabis offenses. We need to get all of them out of jail. It's not acceptable for the state of New York to profit from the sales of cannabis via tax revenue while at the same time incarcerating nonviolent cannabis offenders. And we're going to be working on that very diligently over the coming weeks and months. Thank you, everyone. I hope you enjoyed today's session. We'll see you next week. Have a good one.